Good evening, everyone. Thank you for joining. I'm Michael Ettinger from Ettinger Law Firm, and tonight we're going to discuss components of an estate plan. Before we do that, I'll just introduce myself. I'm the principal of Ettinger Law Firm. I've been practicing law since 1980. You can do the arithmetic, 1980, 2020, it's 40 years. But most of the time, the last 30 years, it's been just elder law estate planning. And in that time, we prepared now over 30,000 estate plans. So I believe we have a good handle on the types of mistakes people make and how to avoid them. So I hope to help you out a little bit to see where you stand and maybe help you move your situation forward a little bit. I am the author of the book, Elder Law Estate Planning, and that's available if you send me an email, mettinger@trustlaw.com. We can email you a copy of that. These days, you can get it right in your email inbox. So I have a screen to share with you. We're going to go over some slides here. Let's see what we can do about that. Share a screen. There's the screen. Press share, and voila! Like magic, we have the slideshow. Now, at the bottom of your screen, you'll see there's a Q&A section. If you want to ask a question, I can't answer it during the presentation, but at the end, I'll be happy to answer all questions. So any questions, type it in, and we'll answer it at the end. Here I am in the middle. To my left, facing your screen, is my lovely wife and law partner, Suzanne Ettinger, and the esteemed staff at Ettinger Law Firm. And we practice limited to trust and estates, wills and probate, tax saving strategies, and Medicaid. And here are offices across Long Island. So we're going to break down a revocable living trust so you can see what is involved in setting up a trust. The parties to a trust are the grantors and the trustees. The grantors, the people who create the trust, the trustees, the people who manage the trust. And they can be the same people. And a revocable trust, they usually are the same people. You put in the Social Security numbers. Well, actually, you don't put in the Social Security numbers. What you state is that the trust uses the same Social Security number as the person who created the trust. This way, you don't have to file a separate tax return for the trust. To the IRS, it's the same as you file the same income tax return as before. So the trust says that the Social Security number will be, if there's a husband and wife, it'll be the husband's or the wife's first and the other spouse after the first spouse dies. But there's never a tax return for the trust as long as one of the spouses is living. And we have the addresses and email addresses and phone numbers of all the parties. So now we know who created it, who's managing it, and where they live and how to reach them. Next, we're going to look at the trustee succession. So you've set up a revocable trust. You put yourself in charge. You run it just like you do now. You buy and sell and trade and spend. No difference. But the key to the trust is who takes over if you become incapacitated. So you avoid having a state-appointed legal guardian. So if somebody's going to take over, if you become incapacitated, the first question is, who's going to decide? And people usually give that to their spouse. And after their spouse, now it becomes one of the children. But the issue here is the family dynamic. Do the children get along with each other? Do they trust each other? Which ones do you trust? Who has the capability of handling your affairs? Who lives nearby? Who might be influenced by somebody else? So we have to explore all the factors and choose, after considering all the options, who's the best person to decide incapacity. And generally, what they'll do, the person will get a letter from the doctor saying, mom or dad is unable to handle their legal and financial affairs, but we need the person who goes to the doctor and knows when it's time to request that letter. So we want to know who takes over. I'm going to know how they take over, which I just explained. And so now we have who takes over in the event of incapacity. So now we have a plan for who's in charge now and who takes over if you become disabled. The living trust is revocable, which means you can take anything out, you can put anything in. You can change who's in charge, who you leave it to. You can amend, cancel, or revoke the trust. So it's very flexible. In fact, the revocable trust is basically the same as you. It's just a plan for who takes over if you become disabled and what happens after you pass away, how the assets get to the heirs. Now, what about your debts and taxes? The trust allows the trustees, but doesn't require them to pay the debts and taxes because that trust is actually not liable for debts and taxes, so it becomes voluntary. For technical reasons, they can't pay the debts and taxes out of the IRA because it would be a forced distribution. So that provides that. What happens with all your personal effects? You can see the china cabinet to my right. Well, we assign all your personal effects to the trust. So we say, all of my personal effects I hereby assign to the trust. Now they're in the trust. This is anything that doesn't have a title, furniture, dishes, heirlooms, etc. Now the trustee is directed, that's the person you put in charge if something happens to you. You're the trustee, but we're really talking about the successor trustee now. The trust provides that the successor trustee should distribute those assets as they see fit. However, you can leave a memo, it's called a memorandum of personal effects, where you specify for special items like heirlooms, which items go to which people. And it's done as a side letter, so that if you change your mind, you tear up the memorandum, you put in a new memorandum, but whatever memorandum is there at the end of the day is the one that they will honor. So the trust says the trustee should distribute as they see fit, but it also says if you leave a memo, they should honor the terms of the memo. Now we take care of the personal effects. Now let's get into the meat of the thing. How do we distribute the assets? Well, first, we have the specific bequests. And specific bequests are dollar amounts to various people. So for smaller amounts, $10,000, $15,000, $25,000, that's a specific bequest. It might be a friend. It might be a longtime employee or a housekeeper who you want to do something for. Might be an in-law, might be a stepchild. All kinds of reasons for specific bequests and all kinds of amounts. Sometimes in a second marriage, the spouse says, well, if I die first, I want my kids to get something like 100,000 or 200,000, and they get the rest after my spouse dies. Because in the second marriage, the person who's in the second marriage wants to take care of their spouse, but also do something for their kids. So they might split it up and say, okay, as I said, 100 or 200,000 on my death, and the rest when the estate is divided after my husband or wife dies. And then you go into the percentages. So after the specific bequest, we say the rest of the estate, it's actually technically called the rest, residue, and remainder. All the rest, residue, remainder of my estate as follows. And you state it in percentages, and the percentages have to add up to 100 because you have to distribute the whole estate. We also have provisions for that surviving spouse in the second marriage for the house. So do they have the right to live in the house? For how long? Can they sell the house and buy a condo? This sort of thing has to be arranged. And then what happens to the house when the second spouse dies? Does it all go to the children from the first marriage? Does it get split up amongst the children of both marriages? And you don't have to leave things equal. We have an expression in estate planning. We say, there's nothing so unequal as the equal treatment of unequals. Bears repeating. There's nothing so unequal as the equal treatment of unequals. This happened in my office today. A fellow came in, fairly well off. He has a family business included in his assets. It's worth about $4 million, including a building that the business is housed in. And he told me he wanted to leave the business to his son because his son is working in the business. And he wants to leave the building 4 ways because he's concerned about the estate being equal. And what I advised him was, well, is the son paying rent? I asked for the building. He says, well, sometimes he pays, sometimes he can't, et cetera. I said, well, if you leave the building 4 ways, it's going to, you run the risk of breaking up your family because the brothers and sisters, all they get is the rent. That's their share. So they're going to want their rent. He may not be able to pay it. They could start fighting about the rent. And, before you know it, they're not talking to each other. And so I said, you may want to consider between now and the next appointment, leaving the business and the building to the son. That's his share. And the rest of the estate goes to the other 3 children. Now, the son may get more, but keeping the family together is important. And the son has an equity interest. He's been working in the business for many, many years. So it doesn't have to be equal. You have to deal with all the circumstances. If you leave it to a charity, you want a specific bequest. You don't want to leave a percentage to the charity, because if you leave a percentage, they can call for an accounting of the whole estate. For example, if they got 5%, they say, well, 5% of what? And they can tie up the estate with their requests and requirements. You might have to deal with the board of trustees of the charity, et cetera. Whereas if you leave them $50,000 or $10,000, they get the money, you're home free. They don't get any right to examine the trust further. We like to put in defense to the trust for challenges. It's something called the interorum clause. You see the word terror in there, and it's meant to scare off any challenges. And what it says is, I'm leaving you this amount, but if you challenge and you lose, your share is forfeited. So if you leave somebody $50,000, they're going to have to think twice before they challenge, because they could lose the $50,000 if the challenge is unsuccessful. And challenges to trusts are very difficult to achieve. So the interorum clause itself will go a long way to preventing somebody from challenging your trust. And if you want to leave somebody out, or you want to leave them less than they think they're entitled to, it's much harder to challenge a trust than a will. So you want to use a trust to avoid a will contest. Remember, a trust is not in court. They'd have to hire a lawyer and sue the trust. A lot of lawyers don't want to take it out. Where the will is already in court, because it has to be probated, so it's much easier to challenge. It's already there. You just file your objections. So a word to the wise if you're leaving somebody out. And the nice thing is, if you leave somebody out with a trust, they don't get a notice. They don't know how much you had, who you left it to. It's not filed. It's not a public record. There's no court proceeding. So they're kind of in the dark. With a will, if you leave somebody out, they still get a copy of the will. They get notice it's being probated. They get notice they're being left out. And they're getting a notice that they have the opportunity to challenge. So again, if you're leaving somebody out, you're going to use a trust. Now we have our trustee succession. You name your successor trustees. Can be one or more persons. They could have the right to act independently, or you can require them to act together. We don't like majority rules. For example, you pick 3 people, say, and 2 of the 3 can decide, because the one that's overruled is upset and angry and can cause a problem next time a decision has to be made. And you put an option that the last named successor can appoint a successor to them. If you have no successors, the attorneys at Ettinger Law Firm act as the backup trustees if you run out. Then we have the trustee voting rights. As I said, could be unanimous, or each of them can act on behalf of the trust without consent of the other, so separate. There's a question whether they have to post a bond, and liabilities. So we generally dispense with the bond. The bond is to guarantee the performance of their duties. With family members, we don't want to burden them with the cost and expense and challenge of getting a bond. Liability, they're not liable for mistakes or errors of judgment, only for willful misconduct, which is legalese for stealing. And we put in a HIP authorization so they can get your medical records, which helps them determine the nature and extent of any disability you might have. If you joined us late, there's a place on your screen at the bottom to type any questions you have. Just put it in there and we'll take all questions at the end. Now, what happens with heirs that are underage or incapacitated? And for us, underage is actually 35. And when I started practicing, well, I started practicing 40 years ago, but I started doing this 30 years ago. We kept it in trust till people were 25, and then we paid it out. And over the years, we found that 25 was too young, so we went with 30. And over the years, we found 30 was too young, so we went to 35, and now we use 35. So it's held in trust. For any heirs under 35, the trustee, who's usually an older, more responsible, more knowledgeable, experienced person, can use the money for them for their health, education, maintenance, and support. Whatever they don't spend, they turn over at age 35. You can pick another age, of course. Why 35? Well, you know, we found that that seems to be a sweet spot. A lot of adult children are not mature at 30. Yours might be, but some others aren't. So we found that to be ideal. It seems to me that as people live longer, the maturation process seems to slow down. Now, if somebody is not able to care for themselves, you can pay it to a guardian or a caregiver who's taking care of them. If it turns out at 35, they let's say they're abusing substances or they have an alcohol problem, the trust provides that if in the opinion of the trustee they're not ready, you can actually hold it back for longer. The spendthrift provision, what that does, let's say somebody gets the inheritance when they're 20, but of course somebody's managing until they're 35. This prevents them from selling their interest in the trust at a discount. They can't go to somebody and say, I'm getting this money at 35. Give me 50 cents on the dollar now and I'll sign you my rights. The trust prevents that from happening, the so-called spendthrift provision. Now, with the trust, you get something called the pour-over will. And the pour-over will does two things. First of all, it cancels your old will, because a later will, as a matter of law, cancels an earlier will. And you don't want that old will floating out there because you have a new set of instructions. So it cancels your old will. And it says, if for any reason I left something outside my trust, pour it in there after I'm gone, because my wishes are written in the trust. Of course, you'd have to probate that pour-over will, so you want to avoid that, but we need it just in case. For example, you could die in a car accident. The other fellow was responsible. Your estate comes into money damages for wrongful death. You're no longer there to put in the trust. This pour-over will catch it, add it to the trust, distribute it according to the terms of the trust. So you need it just in case. Die in an accident, another example. Later in life, you die. You're maybe an heir of somebody else's estate, a sibling. It's in probate for 2 years. You never got the money. Your pour-over will catch that, add it to your trust. We want to mention the elder law power of attorney. Not all powers of attorney are created equal. People come into my office and they say, oh, I'm all set. I have a power of attorney. They put it down on my desk. It's maybe 4 or 5 pages. The elder law power of attorney is 14 pages. And what do you think is on those other 9 or 10 pages? Well, all the powers you need if someone becomes disabled. So I call the standard form power of attorney, the one that most lawyers use, we call that over-the-counter medicine. But the elder law power of attorney is prescription strength, and it works just like medicine. What happens if you need prescription strength, but you only have over-the-counter medicine? You know what happens? It doesn't work. It's not strong enough. Same thing in law. We can't use that standard form power of attorney to move assets if someone becomes disabled. We can't use it to change a trust. So we need something stronger. And the number one is the unlimited gifting power, because if somebody needs home care, or somebody has to go into nursing facility and they want to get Medicaid benefits, they have to move assets out of their name, because under Medicaid, it's move it or lose it. So we want an unlimited gifting power, be able to move assets, save whatever the law allows, usually at least half, sometimes 3/4 the whole thing. But again, you have the right to move it, because otherwise it all goes to the cost of care. And this will allow you to change beneficiaries on the IRA, for example. So if somebody's disabled and their beneficiary is the wrong person, you can fix it. We want rights, as I said, to create or modify the trust. Now, these are powerful rights, but you don't protect yourself by limiting the powers. You protect yourself by picking the right person. If you want, you could pick 2 people and have them act together for additional security. Now we get to the health proxy living will. So we know what the healthcare proxy is. It's a person who will make a medical decision. If the doctor determines in your chart that you're unable to make medical decisions for yourself, this triggers the authority of the healthcare agent, and they can now act. And I just mentioned how that's triggered. And the living will, what's that compared to the health proxy? The health proxy is the person. The living will authorizes the person to terminate life support. And it basically says, if I have no meaningful existence and no hope of recovery, I authorize my agent to withdraw life support, feeding tubes, etc. In the health proxy living will, you can only pick 1 agent at a time. Sometimes people come in and they have a health proxy, name 2 people. That's because the lawyer perhaps was an elder law attorney, didn't know the public health law. The reason you can only have 1 agent at a time is very simple. If you have 2 agents and you don't agree, the doctor wouldn't know what to do. So you pick 1 person, he or she can talk to anybody else in the family, they can reach a consensus, but the doctor is only going to take instructions from the 1 person who's named. And then of course you can have a backup. Next thing, your funeral and burial instructions. So in your own handwriting, we have a document, it's kind of fill in the blanks, type of service you want, type of burial, have you prepaid it? And where is it? Who's going to be in charge of the arrangements? And what tissues and organs do you want to donate if you want to? And then the final instructions to your family. So you fill out and give your family, this is forms, these are forms that we provide, but here's what they need to know to sell your estate: the date and place of your marriage, any subscriptions that need to be canceled, computer usernames, passwords, family, friends, businesses, and professional advisors who should be contacted in the event of your death, and any information you would like included in your obituary. Now we have the plan. We have moved the assets into the plan. We show you how to retitle assets. We'll prepare a new deed to your house and deed it from your name to the name of the trust, so it doesn't have to go to probate and it follows the terms of your trust. You give us email addresses of your financial advisors, and we send them a copy of the trust and ask them to transfer account there into the name of the trust. IRAs, you may know, do not go into a trust. IRAs have a designated beneficiary, goes right to the person's name, so it doesn't go into the trust. If you took the IRA out of your name and put it into the trust, that's a taxable event. You'd owe all the tax. So certainly you don't want to do that. Just change the beneficiaries on your IRAs, your annuities, and insurance policies to the trust. Let's talk about, I like to put a word in about estate planning for larger estates. I don't want to scare anybody off because we handle estates from 100,000 to 20 million or more. But it's important to know, if your estate, which is all your assets, including any life insurance that you own, if you have a $6 million estate, your family will owe over $500,000 in New York estate taxes. If you have a spouse and each of you sets up a trust, you can double the exemption and pass 12 million tax-free. You save the 500,000 on 6 million. On 12 million, you'd save over $1 million in tax. So your tax savings start at 500,000, go up to over $1 million, depending on the size of your estate. Most people don't know this. This is why I mentioned it in every seminar, because you don't have to pay a tax for no reason. This one, you only pay it if you didn't know that you could avoid it, and there's no reason to pay a tax that you could have avoided. So that's estate planning for larger estates. If you want to know more about estate planning, every Wednesday at 2 o'clock, I do a full elder law estate planning seminar. It's entitled 4 Reasons Why Trusts Protect You Better Than Wills. It's much more in depth than this one tonight, but this one is part of my series of Zoom side chats that I gave during the pandemic. And it's snippets of estate planning, but here you get the whole thing. You register at ettingerplan.com, and it's Wednesdays at 2. But don't worry, it should say, don't worry if you can't make it, because if you register at ettingerplan.com and you can't make it, you get the recording. So it's just like watch at your leisure. A word about our law firm's unique planning process. We offer a free initial consultation. You come in, we review you bring in your will, trust, power of attorney, health proxy, review it, kind of an audit, tell you if it's adequate legally, and then you tell us if it's adequate personally. Are these still the people you want in charge? Are these still the people you want to leave it to? See if it needs improvement. Give you a copy of my book, Elder Law Estate Planning. We'll tell you which chapters apply to you. Maybe an hour or change worth of reading. We tell you if you decide to go forward, because we're just getting involved, but people want to know how much I'm in for. We tell you what it would be if you go forward, but we don't generally reach a consensus at the first meeting, because I want people to consider what we had to say, read the chapters. So we generally set up a second free follow-up consultation to have your questions answered. You come in for that second free consultation. We answer any questions you have. We draft the estate plan together with you, provide a detailed written proposal for the fees quoted. So at the first meeting, we quoted them. At the second meeting, you get the written proposal, which now the fees are in writing, and now you decide whether you want to go ahead. And if you do, we don't have you sign an agreement. This is an Ettinger approach. We don't use a fee agreement. We use a fee proposal. We're going to go ahead and prepare all the documents, but no fees are due until after the documents are signed. Now you come in for a third meeting, maybe 2 or 3 weeks later, review all the documents, sign them, and you pay at the end. But until you sign, you have no obligation to the firm. So you're always in control, and we like our clients to be in control. We take credit cards. You can pay all at once or in 3 monthly installments. Once you sign with us, we don't say goodbye. Very, very few firms have any system to keep the plan up to date, but we do. We trademarked it, in fact. We have a weekly Ettinger Elder alert. We say alert because it comes by email. And this way we can keep you up to date of any law changes. Just today, the governor passed a new power of attorney law, simplified it, made it more condensed, easier to work with, easier to execute. Because they found there are a lot of problems with the power of attorney is very complicated to execute the statutory form during the pandemic, so they realized it has to be simplified. So we tell you about these law changes and other matters. Every couple of years, obviously not this year, but every couple of years, we have a client breakfast, update you on what's happening in your law firm, invite your next of kin to meet the lawyers. And there's a free review every 3 years. We send you a letter, time to come in for a free review. We want to meet with you to see if there's any changes in your health, assets, family, births, deaths, marriage, divorces. Not usually a change in the first 3 years, but we meet with you. We renew the acquaintance. 6 years, of course, more people need a change. But the reason we do it is very few people get past 9 or 12 years without needing a major change. Who's in charge, who they're leaving until something else happens. So you do an amendment. Now, the amendment is legal work. You'll pay for that. We're still talking hundreds, not thousands. Amendments may be averaged once every 10 years, but the point is, an Ettinger plan is kept up to date. It's designed to work when you need it, not when you wrote it. It could be decades earlier. So our plans are current. And the nice thing is, when something happens to one of our clients, we know who it is. We've had the breakfast every 2 years, review every 3 years. We don't charge for phone calls, emails, or questions. So we encourage our clients, communicate with us, call us when you have a problem. Don't lose sleep over anything. We'll help you out with it. And they do. So if you like a free consultation, it's worth $500. Other firms charge for it. We don't, but we have the same knowledge. Actually, I would say more knowledge and experience than a lot of firms that charge. Very simple. It's with one of our elder law estate planning attorneys. It can be in the office, by video, or by phone. We can send you a link tomorrow, and you can make your own appointment. It could be by Zoom, or call Patty Brown, my firm manager, at 800-500-2525, extension 117. She's been with us more than 25 years. She can help you. There's her email. So you'll get something tomorrow if you choose. But a better bet would be to sign up at ettingerplan.com for the seminar. Watch that first so you know what you need to know for the consultation. So we're going to stop the share now and see if we have any questions. And so far, no questions. So I will thank all of you for joining. Wish you a nice evening. Stay safe. Happy holidays, everybody. And I'll be back in 2 weeks. Thank you and good night.